As a practitioner in labor law and in labor relations, there's a whole industry that promotes itself as, I can stop this from happening to your place. Can you tell us a little bit about that industry, how big it is and how rich it is?
It's huge. The employers have the right to hire them, obviously. As soon as, in my field, in California, as soon as my client tells me who the anti-union consultant is, the union buster or persuader who's going to come in is, we can tell you just about down to the word the message that they're going to put out. It's a anti-union campaign in a box, so to speak. And they have lots of people who work for them. They come straight on site. They start having one-on-one meetings with employees inside the facility, with the supervisor who is a supervisor from the site, along with the consultant who's being brought in from the outside. They come right in, they sit down, they have one-on-one meetings, they have three-person meetings, they have captive audience meetings, and this all happens very quickly. Generally, before we've even signed the stipulated election agreement, from the date that a petition is filed, we will see those people on site.
The gentleman's time has expired. Mr. Rokita.
I thank the chairman for the time. I thank the witnesses. My apologies for not getting to hear your testimony in person. It's frankly at a budget committee meeting. 'Tis the season in Washington. But I did try to read some of your testimony and had some questions regarding that. Before I got to that, though, I was wondering if Mr. Messenger or Mr. Brown would want to respond at all to the response made to the last question. Mr. Messenger, anything to add or detract from what was said? Is anything illegal about what I heard the term rich being used? I don't know what that implied, or if
no, I mean,
quote unquote union busters were acting illegally or something. Is that what you understand?
No, in fact, the persuader industry exists because the NLRB rules are so tight on employers of a landmine field of all the things they can and can't say that they're forced to hire professionals who know exactly what to say, as Ms. Sensor said, down to the letter, because anything else could be construed to be an unfair labor practice or objectionable. So it's simply a way to get out opposing information within the strict letter of the law.
Absolutely. Thank you, Mr. Brown. Anything there? No? Okay. Just want to be fair. Mrs. Davis, in Mrs. Sensor's testimony, if I read it right, she states, in cases where there is no stipulation and a hearing is held, the election is not held until a minimum of 65 days and often longer after the petition is filed. However, I also saw that most recent NLRB data indicates that 94% of elections are held within 56 days of the petition. So in your experience, is Ms. Sensor's estimate accurate, and why are there delays?
Well, in my experience, even with a hearing, usually an election is held no later than 8 weeks after the petition has been filed. There are going to be outliers that affect the statistics, when you get to the median and the average. But normally, and I advise clients of this, that without a hearing, with a stipulated election agreement, the election's going to be in 6 weeks. With a hearing, it's probably going to be in 8 weeks. So there's maybe a 2-week differential. And the reason why there is sometimes a 2-week differential for a hearing to be held is because very important bargaining unit issues and individual eligibility issues are being determined in that hearing process prior to the election, so that the employer and the employees and the union know who is actually eligible to vote and who can vote. As I said earlier in my testimony, that determination is extremely important when it comes to who's a supervisor and who isn't, because supervisory conduct binds the employer. And when it is not known whether in fact an individual is a supervisor or not, that person can break the rules, bind the employer, and lead to a rerun election. So those issues are very important and should be determined prior to the election being held. The rules will not allow that unless the issue affects more than 20% of the bargaining unit.
How? Deficiency, unfairness in these rules?
I don't think that it's going to lead to any more efficiencies. I think what
I meant to say deficiency,
oh,
sorry,
yes.
and unfairness in these rules as currently written. Is that what you're saying?
Yes.
Yeah.
Yes. And under the proposed rules, it's my position that it may lead to quicker elections, maybe, but it's not going to lead to quicker collective bargaining or collective bargaining agreements, because issues are now going to be deferred until after the election. And until those issues are resolved, the union's not going to be certified and there's going to be no obligation to bargain. So a lot of the concerns that we heard about some years back when there were discussions of the Employee Free Choice Act about how long it takes to get a first contract negotiated, those issues are going to be exacerbated by these rules, in my opinion, because the collective bargaining is going to be delayed because there's not going to be, these issues aren't going to be decided and there's not going to be a certification. It also puts a tremendous burden on employers, as Ms. Sensor testified earlier about the laboratory conditions or the, quote, bubble, I believe she called it. It would require the employer to maintain those conditions all during that time.
Thank you. Switching back to Mr. Messenger, again referring to Mrs. Sensor's testimony, she states, in virtually all the cases where clients have filed election petitions, the employers have been aware of the organizing efforts prior to the filing. In your experience, then, do the employers always know an organizing effort is underway prior to the petition? And is it important for employers to know?
Employees often don't know, or at the very least, they don't know the imminence. So, for example, especially in a large facility, the union only needs 30% of the unit to sign a petition in order to get an election. If you're in a hospital on the second shift, you might not know what's going on in the first shift. And even more importantly, you don't know the actual time frame. So you might hear through the grapevine that someone was visited by a union organizer. What does that mean? Is there going to be an election tomorrow? Is there going to be an election next year? It's uncertain, so there's really no notice beforehand of exactly what's coming.